Alex here with a legal nuts and bolts video on special order after judgment. I was going to call this video filing an appeal revisited because this was already discussed in the video filing an appeal, but I'm really only going to talk about special orders after judgment in this video. I think it's a more appropriate title. Hopefully people that watch the video filing an appeal continue to watch the legal nuts and bolts series and get to this video, and hopefully I'm able to finally put together a more comprehensive sort of, I guess you could say, list or a series of threads for people to watch when it comes to certain topics so that this stuff doesn't get left out. There's a lot that I learned about special orders after judgment that I didn't know at the time, and most of it had to do with just reading phrases either partially or in a way that made sense to me rather than completely and in a way that made sense to the Supreme Court, because they're the ones that are going to interpret that statute, because they're the ones that hear appeals, along with the Court of Appeals now. So there's two important parts of what a special order is. Number one, and I'm looking over to my left here because this is where I have pulled up the documentation, but it has to affect the rights of the parties. This is something that already I knew that made sense to me, but I never really connected it to the rest of the explanation or the definition, I guess you could say it. It has to affect the rights of the parties growing out of a final judgment. I just thought that at the time that meant after the final judgment is entered, but they're talking specifically about the contents of the final judgment. They're talking specifically about what's in that ultimate ruling. When you look at normal lawsuits, I doubt that this is much of a deal because they have a defined beginning, a defined end, a very brief post-judgment phase where usually they just discuss attorney fees and costs, and that's it. So this whole notion of an appeal from a special order after judgment is not as big of a deal as it is with child custody cases in Nevada. And the reason why is because child custody cases don't follow that pattern at all. Sometimes they go to trial, very few of them do. Even if they do go to trial, there's, in high conflict cases, all kinds of motions to modify child support and custody that pop up. Tons and tons of them. And so I would say that in a high conflict child custody case, very little of the case is pre-trial. Most of the case is post-judgment. And in lots and lots and lots of child custody cases, they don't even go to trial. There's just a settlement. And so there's a stipulated judgment or decree of some sort. The case is closed, and then all the conflict pops up post-judgment. And in those cases, it's even a little, it's even weirder because there is an incredibly short sort of case. It's sometimes, with some cases, just a couple months. There is a mediation, boom, case closed. That's it. Their case was open for a month or two. And then it goes high conflict, and they might have 15 years of post-judgment proceedings, which is completely different from normal cases. So a lot of times we end up having to use, as child custody litigants, the special order after judgment type of appeal because most of the appeal is after the judgment. So I'm not going to talk too much about the ordinary way it works. You can watch the video filing an appeal. Ordinarily, you just have to wait till your case is closed, and then you can file an appeal, and you can challenge everything that occurred up until that date. So you may have had 6 different hearings and a tremendous trial and interlocutory orders entered all over the place. Your case closes, you file your appeal, and in that appeal, everything can be considered all the way up until that date. With post-judgment, which is what we're going to talk about now, special orders after judgment, you're trying to get the right to appeal based on that magical phrase. It doesn't seem as magical now as it did at the time. I was really trying to understand what they meant by it, and now it makes a lot more sense. So not only do you have to show that something is affecting your rights to file an appeal, you also have to show that it is growing out of that final judgment. That is the tricky part. Most of the stuff in child custody actually falls within that category. Most of the time when people try and modify, they try and modify their child support or they try and modify their child custody. Both of those things are going to be in that order. Even if you settled your case, doesn't matter. In that settlement, there's going to be something in there about child support, something in there about the custody, and that stuff's going to get sorted out. You can do it whether it's denied or granted. So if the modification is granted and your custodial designation changed or your child support changed, then obviously that affects your rights. But apparently they have decided that even if it's denied, you brought an issue that under the statutes you may have been entitled to a modification of child support or custody, and therefore, in denying the modification, it still is affecting your rights in a way that grows out of the final judgment. Some clues started to pop up into what didn't fit into that category when they started to figure out how to deal with contempt of court. Contempt of court, they decided, and I did a separate video on this topic where I went into it, and there's a case in Nevada that published and explains this. They decided that for whatever reason, it may affect your rights. I mean, you're being jailed or fined, but it doesn't in a way that's growing out of the final judgment. They've decided that it affects your rights in a separate way that has nothing to do with the final judgment. I thought it was confusing because you're trying to enforce the final judgment, but apparently enforcement is separate from trying to change things. Again, guys, I think it's confusing. I wish that it wasn't as confusing, but for whatever reason, that's what our appellate panels in Nevada think. And I guess they got that from other courts that follow the same sort of logic. There's also other types of sanctions that the court can impose, attorney fee sanctions, for example, that for whatever reason, if it's not connected to that final, if it's not growing out of that final order, which I can't imagine how it is, since it's a sanction that they just created out of thin air after the case, you apparently can't get appellate review as a special order after judgment. So it doesn't mean that things are hopeless. It just means you get pushed into writ petitions. Watch my video on the topic, writ petitions, to learn how that works. Attorneys use it all the time because they're not even the parties to the case. So when attorneys get sanctioned and fined, they can't appeal that as a special order after judgment, because that special order after judgment, that judgment itself, has to do with their clients. It's nothing to do with them. Those judgments set forth the rights of their clients. So anyway, there's a lot of attorneys who get sanctioned and then they file a petition for a mandamus because that's the only thing that they can do. Part of it's because they're not a party to the case, and part of it's because of what I just mentioned. I'm assuming anyway. So there are cases that have popped up before, and I really didn't know what to tell my viewers because I didn't revisit the issue. But I've decided to revisit the issue now because it's such a common way, in fact, oftentimes the only way for high conflict child custody cases to go to appeal, because so many high conflict child custody cases in Nevada are post-judgment. I'm imagining probably in the world, most of the stuff is just never ending. So it's just going on, and it's after the judgment was entered. So in Nevada, the only apparent way is to show that not only are your rights being affected, but also that your rights growing out of the final judgment are being affected. If they're not, then you can't appeal. You'll have to look at the video writ petitions and hope that you can get review in that manner instead. I hope that this video makes sense to the viewers. I also hope that it sort of underlines why it's important to have things addressed in that final judgment, because any efforts to change that are going to fit within that category where you can get mandatory review from the appellate courts. Anything else, not so much. This really calls into question a lot of the things that I think happen in post-judgment proceedings. It really makes me wonder, I mean, what if somebody tries to add a provision in there about how insurance is going to be paid? Does that fit into legal custody rights, even though it doesn't have the label? I also wonder about behavioral orders. I mean, does that fit into legal custody rights? I mean, it's hard to say. I think that a lot of stuff that impacts what you can do with your children will in some way, shape, or form fit into custody rights, and people are probably getting special order after judgment classification on appealing that stuff. Probably, I don't know. But I would love to get details from my viewers. In fact, if any of my viewers have been filing appeals that are getting dismissed because they say that it's not a special order after judgment, let us know. Send an email, because that's something that's going to help unconfuse a very confusing area of the appellate process. But yeah, as I said, very common areas where this happens. In fact, one of the areas I already knew is contempt of court. For a long time, I've already known that that was something that they just were not considering on appeal. And now I've also known about attorneys getting sanctioned. I just assumed it was because they were not a party. But I'm finally getting some emails from people who are the party, like they're the parent. They're the parent, and they got sanctioned with an attorney fee award, and their appeal was dismissed, apparently because yeah, it affects your rights to have your money taken from you, but that has nothing to do with the final judgment. It's not growing. The word is growing. It's not growing out of it. Um, Again, if you guys have any questions, feel free to post them down in the comments below, and I will see you guys next time.